Hello dear students, I am Dr. Brinpreet and today we will be talking about Traditional Theory of Criminal Law Part 2. At the introduction, the most recent theoretical advancement in the economic study of criminal law is behavioral law and economics. By utilizing empirical and experimental psychological techniques, behavioral law and economics integrate psychological perspectives into economic models and rational choice theory. It also scrutinizes the underlying presumptions of the Homo economicus archetype, which forms the core of economic analysis. The main idea is that people actually have cognitive biases and frequently behave in ways that deviate them from rational behavior due to their limited capacity for reason, willpower and self-interest. For example, individuals display over-optimism when assessing their prospects or capabilities. The deviations from rational choice are said to be systematic and therefore predictable, that is susceptible to modeling. Providing the economic analysis of law with these behavioral insights is thereby expected to improve the quality of predictions and prescriptions about the working of law.
In the criminal law context, more specifically, behavioral economic analysis challenges the depiction of potential criminals as rational maximizers of their benefits against a particular law enforcement background and deals with the previously mentioned gap between rational choice theory and the decision-making processes of actual criminals, victims, and law enforcers. It highlights how behavioral presumptions about limited rationality impact deterrence. For example, much like other decision makers, potential offenders could also be prone to over optimism, which lessens the impact of punishment as a deterrent. A systematic over optimism among potential offenders, or a discrepancy between the real and subjective likelihood of being apprehended, might result in under deterrence when the cost of crime and the objectively predicted penalty are equalized. The over optimism bias and other departures from the Homo economicus picture of decision makers, whether they are victims, law enforcement officers, or potential criminals, when incorporated into the economic model, facilitate the creation of regulations that would best achieve deterrence in real world scenarios involving real people. With the advent of social norm theory, sociological methods are now being used in traditional economic research in addition to the psychological insights that guide behavioral law and economics of crime. The goal of social norm theory, like that of its behavioral equivalent, is to improve and enliven the Homo economicus model that forms the basis of the economic study of criminal law. While the conventional economic analysis of crime emphasizes the role of choice and agency and sees preferences as exogenous and constant factors, sociological perspectives and social norm theories highlight the critical role that a person's social environment plays in determining their own preferences for engaging in criminal activity. These sociological theories also highlight the interaction between formal criminal law and social norms. The literature on social norms holds that criminalizing a behavior and punishing it can send a message to the relevant community that the behavior is morally repugnant and can initiate the process of social stigmatization. Stigmatization has the potential to impact antisocial behavior in two ways. First, by exposing the offenders to the anguish and suffering that comes with the negative social stigma, it can shape the opportunities and also create incentives for a desirable behavior. Second, by influencing the social norms of the relevant community, it can influence the preferences of potential offenders and enhance their taste for the desirable behavior. Now we will discuss the fundamentals of the economic theory of criminal law. It is quite relevant to investigate the conceptual evolution of the economic analysis of criminal law, starting with the early utilitarian ideas and moving through classical and neoclassical methods to the most current developments in behavioral law and economics of crime. Following Gary Becker's article published in 1968, a long line of research in the economic analysis of crime and criminal law developed, leading to new insights in a wide range of areas, such as the economic typology of crimes, the classification of torts versus criminal laws, monetary and non monetary sanctions, the trade off between the certainty and severity of punishment, the economics of criminal intent, and the economics of law enforcement and plea bargaining. Now, I'll be talking about crime as a negative externality. As already highlighted at the beginning, mainstream economic analysis holds that the concept of economic efficiency is the foundation for the source of illegal activity and prohibitions. Efficiency is assumed to be a beneficial tool for assessing and creating criminal laws and institutions, as well as for drawing boundaries between what is legal and what is illegal. This does not, however, mean that all criminal laws are effective, nor does it mean that the sole criteria by which to judge the normative appropriateness of a given criminal law is its effectiveness. However, efficiency is a key factor in the classification of illegal activity and restrictions in the field of economic research. Two alternative criteria are used to assess efficiency. The Pareto optimality criteria, which states that a society is considered efficient if its resources are distributed among its members in a way that prevents any member from becoming worse off through resource redistribution. A change would be efficient if it could theoretically pay those who lose and yet benefit the person, according to the second, less stringent criteria of Kaldor-Hicks efficiency. A class of inefficient behavior that impose negative externalities, that is, detrimental spillover effects upon third parties that the market is unable to accommodate, are regulated by criminal law. The potential offender's cost benefit analysis keeps these expenses for other people as external. When some actions result in negative externalities, people may choose to carry them even when the cost to others outweighs the benefits, since they do not suffer the costs to others under the traditional economic assumptions of utility maximization. It is easy to see why this situation is inefficient. By paying the person interested in engaging in the activity to refrain from doing so and buying him off to give in to their preferences, those who might be harmed by the act could be made better off without making the person interested in engaging in the activity worse off.
The issue might be framed as one of a missing market, as there are insufficiently profitable market exchanges between the potential offenders and their victims as a result of the negative externalities linked to their behavior. A Pigovian tax is the appropriate response to this scenario. It entails establishing a market wherein the party involved in the externality generating activity bears the associated external expenses, thus compelling them to internalize these costs into their cost benefit analysis. According to Gary Becker, the criminal penalty is like a Pigovian tax. His study infers that crimes are behaviors that create externalities and that this underlying inefficiency is the basis for the rationale behind the prohibition of crimes. Potential offenders are discouraged from doing these ineffective acts by imposing criminal culpability and punishment ex post, which compels them to internalize the cost of their actions to others ex ante.
The tort crime distinction. As has been previously stated, the criminal penalty has a deterrent effect by influencing the potential offender's cost benefit analysis in a way that makes it easier for others to internalize the costs associated with the harmful behavior. However, there are other methods for preventing damage causing behavior and facilitating the internalization of external damages besides criminal legislation and punishment. The tort law system may also serve to achieve these goals. Similar to the criminal penalty, tort remedies may be seen as a Pigovian tax that reduces the difference between the societal and the private costs of engaging in harmful behavior. Furthermore, tort remedies are not only viable alternatives to criminal sanctions, but they can even be thought to be preferable to the traditional criminal punishment of incarceration. There are two causes. Firstly, the social cost of incarceration is determined by the harshness of the sentence, unlike tort remedies, which only require the transfer of money. Second, it is anticipated that information costs will be decreased by the concrete victim's active participation in the tort suit trial and remedy acquisition in his position as a plaintiff. Now, there is a reason to doubt the necessity of criminal law and to contest the difference between these two bodies of law, given that tort law and tort remedies provide an alternative to criminal law and incarcerating punishment, sometimes even a better or a less expensive one. Conditions of insolvency and the ensuing lack of monetary remedies, which underpin the tort law but also the criminal fines to regulate certain sorts of harm causing behaviors, are one major reason for a unique criminal justice system. Cheval argues that in the absence of the possibility of jail, potential criminals will be less likely to commit the crimes that form the backbone of the criminal system, including rape, murder, or theft, which are explained as follows. Number one, there is a relationship between criminality and poor wealth. The exclusive use of financial penalties may not be sufficient to dissuade future offenders given their potential for insolvency. It would be possible for the violators to avoid paying the whole range of penalties necessary for deterrence. Second, the likelihood of detection is low when acts are deliberate or planned and carried out by the criminals who try to avoid discovery. The degree of monetary penalties that would be necessary for deterrence is higher than the ex post damage because of the lesser detectability. This further increases the possibility that the financial penalty will be greater than the offender's financial means. Third, compared to the tort law, the private gains that potential offenders are expected to get from committing the fundamental crimes covered by the criminal code are usually substantial. Because of the increased advantages, there is a greater chance that the financial penalty required for effective deterrence will be more than the wealth of the perpetrator. There is a priori extremely strong evidence that the predicted societal harm from committing the fundamental crimes is large, which supports the limited effectiveness of monetary sanctions as a deterrent. Another reason for a criminal apparatus is the enforcement costs. That means victims cannot always afford the costs associated with detection, proof, and bringing a lawsuit to trial, or may be able to bear these enforcement costs but refrain from doing so because these costs outweigh the harm borne by each individual plaintiff. This is in addition to the worry that the defendant's solvency cannot always accommodate the harm that they inflict upon others through their actions. This lowers the likelihood that people who do not harm will be held accountable for their deeds. Under-deterrence results from a decrease in the likelihood of liability imposition, which is similar to the solvency cap in that it decreases the estimated costs paid by the potential defendants. It follows that public enforcement is required. Furthermore, one additional benefit of imprisonment over monetary compensation and sanctions is its incapacitative effect. In contrast to the monetary remedies or fines, imprisonment keeps the offender from committing new crimes for the duration of their sentence. For all of these reasons, the financial remedies provided by the tort law system are insufficient to control every kind of harmful behavior that occurs in the society. The main goal of criminal punishment is to provide incentives for efficient behavior. So, when the previously mentioned insolvency circumstances or incapacitative advantages do not materialize, monetary remedies or sanctions should be relied upon. It should be emphasized, however, that imprisonment should remain a residual sanction under the economic analysis.
The multiplier principle. The efficiency justifications for the criminalization of specific behaviors and the application of criminal penalties, including incarceration, to people involved in these kinds of actions were outlined in the previous sections. However, as has already been said, using criminal penalties to achieve deterrence is expensive, with arrest and incarceration being the most significant expenses. Therefore, even though it might be theoretically possible to completely eradicate all criminal activity by punishing the offenders harshly and with near certainty, this kind of deterrence might not be the best option given the costs that are involved. For example, enforcement requires resources that could outweigh the benefits of or the savings on social costs from crime reduction.
As a result, a trade-off between the advantages of deterrence and the costs of enforcement arises, raising the question of what constitutes the ideal degree of enforcement and how severe punishment should be. The idea of the criminal penalty as a Pigovian tax and Becker's theory of internalization of damage provide the basis for the response to this query. According to Becker, who followed the Pigovian school, if criminal punishments are set so that their ex ante expected value equals to the expected harm of the crime, the society will be able to limit the criminal activity to an efficient level. A prospective offender would only commit the crime if his or her gains from doing so outweigh the cost of the crime to the society, if the expected punishment is set at a level equal to the expected societal harm. Since the offenders evade capture and trial, the real penalty meted out to those found guilty at trial would need to be greater than the social cost of the crime in order for the expected value of the punishment to match the harm to the society. Now, this leads us to the multiplier principle, which says that the harm produced by the violation multiplied by 1 over the likelihood of punishment is the optimal penalty from a deterrence standpoint. According to this perspective, the ideal punishment should be 4 times the harm that the infraction produced. For instance, if the offender had only a 25% probability of being punished. There are several instances when optimum enforcement does not need a multiplier of 1 over the chance of punishment. Hence, the multiplier principle is not always applicable. The potential offender's propensity for risk is one such exception. Punishment will not have the expected deterrent effect on risk-averse criminals, but it will have the expected deterrent effect on risk-seeking offenders. This means that in order to provide the best deterrent, the fine must be changed until the social harm caused by the offense is equal to its discounted or inflated disutility. A second instance where the multiplier principle is violated and adjustment is necessary is when the criminals face extra legal penalties on top of the official penalties they face. For instance, in addition to the expense of the sentence imposed by the state, the criminals may incur very high reputational costs upon conviction. The best deterrence in this situation is also obtained by departing from and modifying the multiplier principle. The social cost of the offense should be measured not only in terms of the official criminal punishment but also in terms of the expected value of all the legal and extra legal penalties that the offender will likely face. Usually, this means extrapolating the official sanction that would otherwise be required to determine the legal punishment. Now, probability versus severity trade-off. How does this work? Following a discussion on the ideal degree of enforcement and the appropriate penalty based on the trade-off between the expense of enforcement and the advantage of deterrence, the best trade-off between the two factors that make up expected punishment and enforcement costs, that is the cost of punishment indicated in the severity of a sentence, and the cost of apprehension and prosecution, which is indicated in the likelihood of conviction, becomes apparent very quickly. Put another way, when the projected sentence for the offense has been determined, it is vital to determine the best compromise between the likelihood and severity of the penalty. For instance, a risk-neutral criminal is considering whether to commit a rupees 10,000 crime that would hurt a society or not. The multiplication principle states that the criminal penalty should be set at rupees 20,000 for a minimum when there is a 50% chance of punishment. If the likelihood of punishment is reduced, let's say to 20%, the multiplier principle requires a rupees 50,000 sentence. Since the expected punishment in both the cases is the same, the offender would have no choice but to comply. Which of the two eventualities is more desired and efficient would be a crucial question for the social planner though. Naturally, the sheer act of asking this question deviates from the retributivist tradition's foundational concept of proportionality. The proportionality principle requires that penalties should be applied in a formulaic manner appropriate to the moral seriousness of the underlying offense. The retributivists oppose the breaking of the link between crime and punishment that results from combining the enforcement and prison spheres. These concepts are directly at odds with penal variability, which is determined by the likelihood of conviction. However, the institutions supporting a binary relationship between the severity of the penalty and the likelihood of conviction do not fit the overall framework of the economic approach, which emphasizes the deterrent effects of criminal punishment. Under the economic theory of criminal law, deterrence may be influenced by changing the likelihood of conviction or the severity of the penalty, and these two factors are seen as interchangeable. This further gives us the opportunity to address the original question, that is, what is the best compromise between the likelihood and the severity of punishment? It is helpful to split the debate between instances of monetary penalties and non-monetary sanctions in an effort to address this subject. First off, the penalties are seen as nothing more than money transfers from the criminal to the state, as was previously indicated in relation to the first group. Such monetary restrictions are thought to have no cost associated with them. The social cost of a rupees 10,000 fine is the same as the social cost of a rupees 50,000 fine. On the other side, it is assumed that locating and prosecuting the perpetrator will need societal resources. There are societal consequences when the likelihood of conviction is increased from 10% to 50%. According to Becker, the most efficient trade-off would be to set the sanction as high as possible while keeping the probability of conviction and the associated enforcement costs as close to zero as possible. This is because increasing the size of the fine has no cost, while increasing the likelihood of conviction raises the cost of enforcement. In contrast to Becker, Polinsky and Shevell argue that there is a connection between the size of the fine and the social cost associated with its implementation, challenging the idea that fines are a straightforward example of transfer. They contend that Becker's theory does not apply to risk-averse criminals for whom an increase in the fine in tandem with a decrease in the likelihood of conviction only creates an extra risk that, unlike the punishment, is not beneficial to the society.
To conclude, I will say that the economic principles that underpin the economic approach to criminal law set it apart from other theoretical stances on the subject. In this approach, potential offenders are seen as rational utility maximizers who are susceptible to incentives rather than as deviant people with abnormal capacity for making decisions. Changing the expected reward for future offenders is the main goal of criminal legislation and punishment in order to discourage people from committing undesired crimes. Put differently, the economic approach to criminal law emphasizes the deterrent role of punishment rather than the retributivist ideas of moral guilt, seeing it as only one particular application of the universal principle of rational choice. Lastly, efficiency is accepted as the normative standard by the economic analysis of criminal law for assessing criminal laws and institutions. And with this, we have come to the end of this lecture. Thank you very much for your patient listening.